No stairs on this side.
Well, be careful.
Yes.
Be careful. So,
Yeah.
Hunt's going to say a few words.
Sure.
And I'll jump up and kind of introduce what we're doing. He's going to introduce everybody on the partnership.
Yeah.
And I'll talk about Constitution Day. I'll talk about our strategic objectives.
Good.
In particular ones dealing with limited government and original intent.
Yep.
And then I'm going to say, and our first speaker is
Good.
Dr. Steven Shoemaker.
Okay. Now the question I have is Stacy going to get the PowerPoints running?
I don't know. Let's go ask her.
Let's go ask her. No. Well, let me do it. You get your thoughts on it.
Would you ask her if she's already got the
Squeeze right here next to you.
Yeah, well, they got us in here tight.
I know.
They really did.
Keeps it all together. Great. Good.
Okay.
Good.
Hey, how's it going? You met my wife?
No,
That's clearly my better half.
Susie.
Remember John Andrews?
Yes.
So he was in charge of the Smith Institute, and he's
recognize.
handpicked his
Yes.
successor.
Oh boy.
You doing
Well, yes, I hear your name often. You must be doing well.
You probably see him on Facebook too.
Yes.
Yeah, he's quite adept at the
Yes,
social media.
lots of emails come to me. Jeff.
Yeah, that's
Yeah.
right. Jeff Hunt.
Yeah.
So you're first up.
Yes, I am.
So we're going to start proper at 7, but I've got a few remarks.
Yeah, Kyle said that, and he's going to talk about strategic. Good. So I think I'm good. Good. All right.
Great. This match is Crcel.
Really? Well, I can see that. Yeah. Yeah, you can see it. You can see it. Yeah, you're welcome.
Hi, Eric Baxter.
Steve Shoemaker.
Steve, nice to meet you.
Nice to meet you. Sorry I missed dinner.
Oh yeah, well I
It was
almost
great.
did too. I got my Uber driver and I had a little miscommunication. I ended up downtown Denver. And
Oh no. And downtown Denver is not a place to be. It's so
And
messed
it's
up.
not Lakewood.
it was not Lakewood.
Yeah. Wow.
It was a comedy of errors. There were multiple points at which one or the other should have known. Something went wrong, and we somehow went through all of it without.
Oh, mercy. So I guess we're going in this order, huh?
I think we're going in, yeah, and you're doing some background or something, or some history.
What I'm going to do is actually talk about civic friendship.
Okay.
As a kind of, at the end of the day, we got to somehow figure out, I mean, we got to do the legal stuff,
Right.
but nothing's solved till we
Need
figure
a
out how to
bigger
be
culture,
friends. Right, culture issues.
Better culture, yeah.
Yeah. So let you do all the technical stuff and all.
I'm really looking forward to it. And do you teach here at
Yeah, I do.
CCU? Okay.
Yeah, I just finished my 5th year here.
Oh, excellent.
Teach politics.
And you're on Colorado Public Accommodations?
I am the most boring of all because I am the very technical, Colorado Public Accommodations and Anti-Discrimination Act and Commission specifically.
We're so happy.
Well,
You guys get to do the fun stuff, and I'm just the technical stuff.
That's what we're hoping.
the thing is, most people don't know about how much happens in the commission, how much of their constitutional rights are, subject to this kangaroo court.
As all lawyers know, the devil really is in the details.
Yeah.
You get down into the details, it's like, oh, I can see why they wanted to, wanted to file with the commission.
Right.
Because here are the advantages of this.
Right. Right. Yeah. It's when you're put in those shoes that you get a better sense of challenges. You know? Right. Yeah. Great.
All right, we're going to get this started. Can you hear me okay? All right, we're going to start our evening off. Welcome to the September 2018 Distinguished Lecture Series. It's been so good to be back with you all. The last time we held this was right before the Western Conservative Summit, so welcome back to a brand new school year. My name is Jeff Hunt, and I'm the Vice President of Public Policy at Colorado Christian University and Director of our think tank, the Centennial Institute. We're so grateful that you're here for this important discussion. Our Distinguished Lecture Series are our monthly lecture series featuring the brightest minds, exploring the most challenging issues of our time. Tonight, we're excited to explore religious freedom and its protection in the First Amendment of our Constitution. To begin our evening, please stand and welcome 1776 scholars Kendall Bourne and Weston Ives as they lead us in prayer and the Pledge of Allegiance.
Father God, I thank you for bringing us here together today. And I thank you that we can come and pray to you in freedom. I thank you that we are in a country where that is possible. And please, Lord, let us never forget how valuable that freedom is. Please, Lord, bless these speakers that are here today. Give them wisdom and the right words to speak. And all of us who are gathered here to listen, let us listen with discernment for your words. Let what we hear today inspire us to change, to make an impact in our community, and give us clarity and open minds as we listen to this topic. Give us hearts to hear, Lord. And above all, Lord, let us always do your will. In the most holy name of Jesus, amen.
All right, please join with me for the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great. You may be seated. Friends, Colorado Christian University was just ranked the #7 most conservative college in America, up 2 places from last year. Due in part to our wonderful students' commitment to our country's founding principles. Thank you again, Kendall and Winston, for leading us this evening. On Monday, September 17th, we will celebrate the 231st anniversary of the signing of the U.S. Constitution. In honor of this occasion, the Centennial Institute and Colorado Christian University present a special evening on the uniqueness of the American Constitution and advancing religious freedom. Friends, the freedoms of religion and conscience protected in the First Amendment are under attack in ways we've never seen in this country. Radical activists using laws to prevent legitimate discrimination are specifically targeting Christians, dragging them before government entities like the Colorado Civil Rights Commission, and forcing decade-long legal battles. Jack Phillips just endured a 6-year legal battle that culminated in a 7-2 Supreme Court decision in his favor. Colorado Christian University was proud to stand with Jack Phillips in these legal battles. But unfortunately, Jack Phillips is once again facing Christian persecution from the Colorado Civil Rights Commission. And once again, Colorado Christian University pledges to stand alongside Jack in this latest battle. As a society, we must work together so that the LGBTQ community is not treated like second-class citizens, while respecting the fundamental human right of religious freedom protected in the First Amendment of the U.S. Constitution. To help us explore these issues, I'm proud to introduce our panelists tonight. First, we'll hear from Dr. Steven Shoemaker. Dr. Shoemaker is entering his 20th year teaching graduate and undergraduate courses in philosophy and politics. He is currently professor of politics at Colorado Christian University, where he specializes in political philosophy, political theology, and American political thought. He is married to Susie, his wife of 28 years. Susie, I saw you earlier. Raise your hand right there. Great. And has 3 children, Stephen Jr., Autumn, and Micah. Then we'll hear from Eric Baxter. Eric Baxter is vice president and senior counsel for Becket Law, Religious Liberty for All People. He received his BA from Brigham Young University and his law degree from J. Reuben Clark Law School. Eric Baxter joined Becket as senior counsel in 2011. Since then, he has represented religious organizations and individuals in a wide array of religious liberty disputes at both the trial and appellate level. His case victories include a 9th Circuit ruling upholding the Big Mountain Jesus statue that has stood on Forest Service land near Kalispell, Montana for more than 60 years, and a rare Pentagon decision allowing a Sikh, in the religious sense, or Sikh, soldier to maintain his full beard and turban while serving in the Army. Eric has extensive experience fighting efforts under the state Blaine amendments to exclude religious organizations and individuals from participating on equal terms in the public square. He also regularly advises religious institutions of higher education in defending the religious missions against government encroachment. On this note, Becket defended Colorado Christian University when we were the first interdenominational Christian college to challenge in federal court the Obamacare mandate that requires private employers to pay for abortifacients in their group health plans. Because of Eric and Becket Fund, we were able to win that important case. We'll then hear from Eric Hall. Mr. Hall received his undergraduate degrees from William & Mary, his master's from St. John's College, and his law degree from Notre Dame Law School. He represents religious institutions and schools in all legal matters. His practice also focuses on complex civil litigation at the trial and appellate levels, with an emphasis on First Amendment litigation involving religion and speech, as well as commercial litigation of all types. Then we're going to hear from one of our very own, Brenna Graz, who's going to be coming in via Skype a little bit later. Brenna is a former CCU student and Centennial Institute 1776 scholar. She graduated summa cum laude in 2015 from CCU with a degree in business administration and is now a third-year law student at the University of Nebraska College of Law. She is currently online editor of the Nebraska Law Review and vice president of both the Federalist Society and Christian Legal Society. Brenna is an Alliance Defending Freedom Blackstone Fellow. That means she's going places, and has worked as a law clerk for the Nebraska Attorney General's Office and for a private full practice firm in Lincoln. After she graduates, this is where our CCU students go and why we're so proud of them, she'll be serving as a judicial clerk in the Nebraska Supreme Court. Finally, we'll hear from Dr. Kyle Esri. Dr. Kyle Esri is a world-recognized professor of law, including international law, and has taught economics, ethics, marketing, local and state government law, constitutional law, international business, and international law in many places over the globe. He is from Boulder, and he and his wife have lived and worked on 6 continents via the practice of law and in higher academia and as missionaries. He is a former university president, former administrative judge, and he and his wife have 2 adoptive children from China and Cameroon. He is now serves us here at CCU as the Vice President of Academic Affairs in the College of Undergraduate Studies. At this point, I'm going to turn it over to Dr. Usry to make a few remarks.
Thank you, Jeff. Today we are celebrating Constitution Day, which is an American federal observance that recognizes the adoption date of the U.S. Constitution and those who have become U.S. citizens. It's normally observed on September 17th, so we are a week early. But we're celebrating that day in 1787 when the delegates to the Constitutional Convention signed our Constitution. Our Constitution, by the way, is the oldest and shortest Constitution on the planet. The law establishing the present holiday was created in 2004 with the passage of a special act. The act mandates that all publicly funded educational institutions and all federal agencies provide educational programming on the history of the American Constitution somewhere around that day. In May 2005, the United States Department of Education announced that the enactment of this law and that it would apply to any school receiving federal funds of any kind. My policy as a VPAA is we should do this without the mandate. It's so important. Also, I want to talk to you a little bit about Colorado Christian University's mission and strategic priorities. Our mission is Christ-centered higher education, transforming students to impact the world with grace and truth. Our strategic priorities direct the implementation of CCU's mission, provide a context for our first priority, which is an enduring commitment to Jesus Christ and his kingdom. The strategic priorities provide a point of convergence for every member of CCU community, faculty, staff, students, and for every aspect of life at CCU, from how we teach to how do we learn, how we live and serve others. Some of our strategic priorities are honor Christ and share the love of Christ on campus and the world. Teach students to trust the Bible, live holy lives, and be evangelists. Teach students how to learn. Teach students how to think for themselves. Teach students how to speak and write clearly and effectively. And the one that's really important tonight, they're all important, is this one, number 8. Impact our culture in support of traditional family values, sanctity of life, compassion for the poor, biblical view of human nature, limited government, personal freedom, free markets, natural law, original intent of the Constitution, and Western civilization. We seek to be seekers of truth and to become a great university. Thank you for being here tonight in our celebration and in learning from each other about not only how complicated these issues are, but how can we get out of this box that we're in First Amendment. At first, I want to introduce Dr. Steven Shoemaker, a friend of mine, and he will speak, followed by the rest of us on the panel. Steve.
Hello, can you hear me? Is that good? All right, I'd like to return the favor. I'd like to thank Dr. Kyle Usry for not letting me weasel out of this panel like I first intended. And since no good deed can go unpunished, everything I say and do tonight can and will be held against you. My friend. All right, let me begin here. Make sure I got this figured out. Maybe the other way. Oh, you have something there. Okay. When Jesus said that we must become like children to enter his kingdom, he said something both intuitively beautiful and yet deeply mysterious. What exactly did he mean? I can't say that I know for sure, but in watching children, it seems clear that they exude great hope and joy of life. I would like to invite all of us to embrace such childlikeness tonight, especially its hope. And I say this because these feel like unusually contentious times. The issues that divide our nation are legion and all seemingly intractable and inescapable. Our over-politicized culture has devolved into a swirling Gordian knot, leaving the average person on the street either mystified or just angry and sad altogether. As one of my former students put it, where are we going and why are we in this handbasket? The topic of tonight's panel provides no refuge. It's one of several issues that constitute the great eye of this cultural storm we're living through. To state things technically, the central question of religious liberty today is whether equal citizenship within an inclusionary constitutional republic demands occupational exclusion for someone exacting dignitary harm for sexual orientation, or whether such state action is blatant creedal discrimination. Whew. Happily, I leave it to our legal experts to translate that into English, and instead wish to touch on the moral, social, and spiritual side of the question. For the greatest problem this issue entails is neither constitutional in nature, nor can it be solved by constitutional measures. The only way forward is to rediscover the meaning and significance of civic friendship. Western civilization, historic Christianity, and the American experiment in constitutionalism are unparalleled resources for us to rediscover such friendship. And I'd like to draw on these rich resources tonight to enable such a rediscovery. The relation of civic friendship to justice has a long history, extending back to the foundations of Western civilization. It was Aristotle who noted that justice, however important as a foundation for community, is far inferior to the benefits of civic friendship, and that civic friendship creates and constitutes the health of one's community. As he puts it, when people are friends, there's no need for justice. But when they're just, there is still need for friendship. A moment's reflection on this confirms its truth. If you're sharing a bag of chips with your friend, college students, the last thing you do, hopefully, is to keep track of the number of chips you eat each in order to make sure that your friend doesn't eat more than you. Genuine friendship can never be so petty because it necessarily involves goodwill, generosity, and the satisfaction of sacrificing here and there to see your friend smile. On the other hand, justice is decidedly limited in developing community because it's too exacting and often involves punishment. By its very nature, it lacks generosity and nobility. To put things bluntly, one does not bond with a judge who rightly sentences you to jail, nor does your heart swell with affection for your jailers. In short, to merely and always and bitterly demand unremitting justice is to live less than a noble life. Surprisingly, it's unworthy of a life well lived, and no amount of lawsuits or favorable Supreme Court rulings can elevate a community above mere justice towards the nobler ground of civic friendship. Similarly, biblical Christianity offers a cautionary tale which illuminates why civic friendship is so hard to come by. According to the Bible, human beings are a race of kings, created to responsibly rule God's creation. We have an inborn desire to see our vision for the world come into existence through our own efforts. Unfortunately, the Bible also teaches that we are a race of fallen kings who need salvation, moral and spiritual rebels determined to define good and evil for ourselves and at the expense of others. Now, this, if nothing else, makes for an interesting, complicated creature, especially when you watch us try to run our corner of the universe. What you'll see as the Bible tells it gets dark fast. It's not an accident that the very first sin recorded in the Bible against a man involves a brother against a brother. And it's not just a sin against one's physically closest equal, but a crime. And it's not just a crime, but murder, the worst crime one can commit. To make matters worse, the story reveals that this murderer feels nothing. The key to this story, why it relates in a frightening way to each of us, is that we can all see ourselves in why Cain acted as he did. Cain thinks, feels, and acts like a fallen king. As a king, he's a creature of great self-importance. He feels pride in his own inherent dignity. As a fallen king, however, he is highly susceptible to wounded pride. When God rejects Cain's offering, he considers himself dishonored, and moral indignation consumes his heart and mind. Completely blinded by his moral indignation, Cain lashes out in bitter destruction with no evidence of any conscience. He knows and feels that his otherwise horrible actions are justified. After all, what is one's brother's or one's baker's or one's florist's innocence in comparison with assuaging one's own sense of dignitary harm? Abel, though he did no harm, had the singular misfortune of merely wounding a neighbor's pride. The point is that any of us could be Abel, and any of us Cain. We are as vulnerable to destroying others without a conscience as to being destroyed by the same. Let me now turn directly to the connection between our Constitution and civic friendship. Interestingly enough, the original Constitution was deliberately designed by its framers to prevent the very kind of government that we have today. Our founders understood that civic friendship and liberty were best secured through local and regional self-government. Because people in various regions are different from each other in politically important ways. Just think about the torture and elation surrounding the election of President Trump, and you understand. The framers designed a constitution that would restrict the federal government from interfering almost entirely in everyone's daily lives. As the Frenchman Tocqueville noted in 1835, he said the average American would spend his entire life without ever bumping into the federal government. Sign me up. Right. I'm all for that. Our founders designed things in this way because they expected regional civic friendship to support the American system rather than pronouncements of a handful of distant legislators and judges. Finally, let me touch on the 14th Amendment and conclude. This amendment has become the constitutional epicenter for litigating charges of discrimination. Its due process and equal protection clauses have been used by the Supreme Court to rewrite the Constitution as they wish. Actually, however, an originalist reading of these clauses directly addresses dignitary harm, the central charge in the Masterpiece Cake case. Properly understood, the 14th Amendment guarantees that, to quote, to be an American is to be subject to other Americans' assessment of honor, dishonor, and yes, insults, but also to have room to give and inflict one's own assessments. It is civic friendship and not the law that must alleviate the damages of dignitary harm. Let me close by returning to childlike hope and offering what I take to be the only real solution for going forward together as a nation. What we need is for decent, sane-minded citizens from all over Colorado and from every community, whether Christian or LGBT or otherwise, to somehow reach out to each other and then tell our state government just to stop. Excuse me, to stop picking on little people who've done no substantive harm, to stop trying to solve a non-legal problem by bullying them with legal whips and chains, to stop caning around with our chance for civic friendship. With all due credit to our country's greatest wordsmith in chief, we can all come together and declare, we are not enemies, but friends. We will not be enemies. Though passion has strained, it will not break our bonds of affection. The mystic chords of civic friendship will swell when again touched, as surely they will be by the better angels of our nature. Thank you.
Well, good evening, everyone. It's great to be here. I was last here, I don't know, a number of years ago when this building was on a construction sheet with plans that Steve Miller showed me, and so it's really exciting to see the growth of the campus. And and to be here again with you. I really appreciate the invocation of hope and how we can, culture is an important source of how we change the world. Of course, I'm disappointed when people aren't looking to lawyers first. I do have a family to support after all, but no, I really would love to put myself out of a job. If we could really preserve religious liberty and make sure it was secured, I'd be happy to move on and do some other work. But in the meantime, the fight's a great fight, and I'm actually very optimistic when I look out. We hear on the media a lot of times the negative side, and we forget that in the last 7-8 years, the Supreme Court has delivered a number of very important religious liberty or decisions protecting religious liberty. That we have a lot of new judges coming onto the bench who understand the constitutional principles and want to apply them. So I think there's a lot of great things to look forward to in our future, and I think we should be optimistic and continue not stop fighting, but carry out the fight with optimism and hope for the future. I was assigned to talk a little bit about the Masterpiece case. I'm kind of like walking into the group of most knowledgeable people on the case. I hopped in my Uber on the way here, and he asked what I was doing. I told him, he's like, "Oh yeah, I can drive you right over to the shop if you want. We're going to pass it." So I was like, preaching to the choir a bit here, but I do think there's some really important principles that I want to emphasize and just talk about how this case, the importance that it has, not just for Jack Phillips. And not just for Christians, but for all Americans of all religious stripes or of no religion at all. So as you know, of course, Dave Mullen and Charlie Craig went into the Masterpiece shop to order a wedding cake, and Jack Phillips declined to create for them a custom cake to celebrate their wedding. They sued him in the Colorado Civil Rights Commission, and basically, he was told by the state that he needed to bake the cake, change his policies, and educate his employees to know that they had to bake a cake. And I'm sure you've all heard Jack's statement, just that he had to stand by what he believed was right first. And I can tell you, all of our clients face either being sued by the government or suing the government, and it's a very scary thing to look out and know that. I'm representing students right now at the University of Iowa, and for them to sue the state, essentially, the university that's going to give them a degree, that's hiring their teachers, that's making sure that they're going to helping them get jobs, it's a very scary thing to do. It takes a lot of courage for people to take that step. And so Jack Phillips, is obviously a very commendable example in that respect. But in this case got to the Supreme Court, the court recognized there's two principles at issue. One, the state does have the power and the authority to protect groups that it believes are suffering discrimination. We have all kinds of laws that protect different groups or individuals and their rights. But the court also recognized that can't always and should rarely trump fundamental First Amendment rights, freedom of speech, freedom of religion. That you have to, what the court says, take a close look or apply strict scrutiny before you can overturn constitutional rights. And, a lot of people were very disappointed because the court didn't actually resolve how that balance plays out in this case. They said, we recognize the state has some authority to protect groups, including members of the LGBTQ community, but there's also an obligation to respect constitutional rights, and sometimes those are going to clash, and we don't actually know how that's going to come out in this case, but the court announced a very important principle, and that is that when you are before a judicial body or another government agency that's adjudicating your rights, you have the right to have your religious beliefs treated neutrally and treated on the same level as other people's conscientious rights or beliefs. And that's a very important principle. So the court announced, 7-2 announced, that, they basically told the Civil Rights Commission that they had to vacate their decision because they had made statements during the proceeding like, if you want to do business in this state, you have to put aside your religious beliefs. Or if you have to compromise, right? One of the commissioners said that it was a despicable piece of rhetoric to say that your religion wouldn't allow you to serve someone. And Justice Kennedy says that's wrong on two fronts. It's wrong to assume that someone's religion is despicable. A government agency body has to treat those views like it would treat any other view, even if the individual official hates those views, disagrees vehemently. they have an obligation, Justice Kennedy says, to pause and think about their constitutional obligation to treat everyone equally that comes before them. And he says it's also wrong to call it a piece of rhetoric and to assume that this belief is something that's being used for political purposes or just to win a point. He said government officials have an obligation to treat your views as sincerely held, something that you mean sincerely and with good intentions, and not to assume that you're doing this for illicit purposes. The court also recognized that there had been another individual named Jack Williams who had gone to several other bakers and asked to bake cakes that the bakers thought were disparaging to members of the gay community. I think the cakes had 2 groomsmen holding hands with a big red X over them and then biblical statements about sin and things like that. And those bakers had declined to make those cakes. Jack Williams had sued them, or William Jack. I get confused between Jack Phillips and William Jack. William Jack had taken these other bakers to the same commission, and the commission said, oh, it's okay because they're refusing to bake these cakes because the message is so offensive. And the Supreme Court said that right there is evidence that you were not treating everybody neutrally and giving respect to everyone's opinions, because you said that some bakers' views of what was offensive was protectable. They had the right to deny someone's religious statements, a religious cake, because you found their views despicable, but you wouldn't allow Jack Phillips to decline to create a custom wedding cake for views that he disagreed with. And so a lot of people were very, I think, disappointed that the issue wasn't finally resolved. And there are a lot of complicated issues. The court expressed concern that, and all the justices on the court, including the most conservative justices, recognized that someone who wanted to deny complete access to any goods and services in their store to gay individuals, that the government has a compelling interest in, even if that were motivated by a sincere religious belief, the government may very well have a compelling government interest that would say we won't allow that. But where there's, a baker has expressive rights. I read a really great article that was talking about when President Trump was elected, and there were a lot of dress designers who didn't want to participate in any way, including by designing a dress for the First Lady. And that same idea that we respect people regardless of whether we agree or disagree with their views, the freedom of to hold our own beliefs, to express those beliefs, and to act on those beliefs, and a particular protection for acting on our beliefs when they're religious beliefs, that the government has to treat us, all of those views, equally. Even if some of those views are abhorrent by majority views or minority views, whatever, they have to treat them equally. And I really like that they said that government officials must pause and reflect on their duty to do this. And I think it's just a clear reminder that plaintiffs and parties to lawsuits and other adjudication procedures can say, like, look, take a pause and think about this from a neutral perspective. This, of course, goes well beyond just, baking cakes in the wedding industry or protecting Christian views. It's really a view that protects people of all faiths. And I want to just share a few examples of ways that this is true. I mean, there was in the Washington Post, it's maybe been about a year now, I can't remember, but there was an article about a Muslim group in Virginia that was seeking to expand on their mosque. And they were running into a lot of problems with their zoning authority, which happens a lot when you have small minority religious communities who go before their zoning board and want to expand, and all of a sudden all of the community comes out and like, oh, parking and congestion and noise, and there's a lot of complaints. And they had a video on the Washington Post website where someone stood up in this zoning board committee and said, these are all terrorists and they need to go back to their home countries. And, these are people who have been in America for as long as, any of us, and who are peaceful, believers in God and who exercise their faith. We might disagree with them vehemently. At Beckett, we call it the right. We have the right to be wrong, right? We're not here saying, hey, diversity is where it's at. We're saying we're not respecting it because we think it's like a multitude of views is good. We might think that there's only one way, right? but we respect everyone's right to be wrong. And so those individuals, Muslim members of our community who are before that board, they're protected by this decision. They have the right to say to that commission, look, there's a lot of heated rhetoric here. There are a lot of strong views here. But you have an obligation to consider our application just like you would consider it for anybody else. And that's an important right that especially is going to protect minority religious groups who are more likely to be subject to discrimination in ways that we don't, those of us who are in a majority religious position, we see more and more attacks coming on Christian religion, but many of these minority groups have been living with this for many, many years, where in small communities and in their states, the discrimination they're experiencing is not being publicized. And so this is a super important decision for them. The case representing the Sikh soldiers was mentioned. My client, Captain Simratpal Singh, came to the United States as a 9-year-old with his dad who had asylum status because of the persecution against Sikhs in India at the time. Came, all-American kid in high school, served on the student counselor, was a wrestler, had never shaved. Had this rocking beard as like a sophomore in high school. And a turban, always wore a turban. As part of the Sikh faith is to never shave because it's, taking away from what God gave you, and always wearing the turban. And the turban has become a deep part of their identity because of the religious persecution they experienced in the many hundreds of years of their early experience, where they would often be forced to shave as a form of conversion when they'd be conquered by Mongols or others. And those who refused and were usually beheaded for refusing to do that, they became the martyrs of the religion. So it's a very strong part of their identity to always wear their turban. And one of our clients was forced in boot camp to remove his turban. He said, for a Sikh, this is like being forced to strip down to your underwear. He said, I never take my turban off, even in front of my family. He said, I'll take it off to sleep and to shower, but I don't, just run around without my turban on. And so this soldier, Captain Singh, wanted to just enlist in the Army, had a real love of our constitutional values and of America and the opportunities it had given his family. So he was going to enlist. He found out about West Point from one of his friends. And he's like, maybe I could do West Point. And he started applying and going through the procedures. He had a recruiter who's like, what's with the beard? trying to last hurrah. He's like, no, this is like who I am. This is part of my religion. And the recruiter was like, I don't know if you're going to be able to do that. And he never really got a clear answer. And he was still asking the day he showed up on reception day at West Point and said, they're putting you through the line, shoes, socks, pants, last stop, barber chair. And he said, I've been applying for it. Am I going to get my accommodation? This is America. And they said, you got to shave or go home. And he made the decision right there that he would serve his country. And he, sacrificed really what he felt was a core identity of who he was, and the great guilt that comes with that when you feel like you're betraying, the God that you know and love. And the barber, I think this was a very touching moment, recognized, not knowing much about the situation, but recognized that something very serious was going on, offered to braid the hair and keep it for him, and bound it for him and wrapped it for him. And he said he carried that for 10 years as a reminder of his burden to return to his faith. And he came to us in 2015, asked if we would represent him. He said, I feel like now is the time to try to live out my faith. The Army had recently made some changes that suggested they might be more open to it. But you imagine, he had become an Army Ranger. He had spent time in Afghanistan clearing military roads from IEDs, and really sacrificed fully for our country, a Bronze Star Medal recipient. And he had been sent back to do engineering, a master's degree in engineering, and when he finished that up, he was being assigned to Fort Belvoir in the Washington, D.C. area, and he said, this is my time to do this. And we said, well, you don't have if you show up with a beard, you could go into the brink, right? And so we started writing letters for him. His commander was very supportive. We got some short-term accommodations. He showed up at work. His team was really supportive. But from the Pentagon, we were getting, all kinds of pushback on what we were trying to do, and threats that he, basically subjecting him to unfair testing, making him, he's the guy who's a captain in the army, and they're saying you have to always be under escort, because you're wearing a beard, you're dishonorable, and it was, interestingly, it was members of the Obama administration who took on his case and really pressed the Pentagon to change their policies. And we ended up suing. We did over a year of litigation before we got the Army to change its policies, but now they will accommodate all Sikh soldiers who, by the way, had served up until 1981 in the military. Since we have some pictures, we're not sure how legit they are, but going back to the Civil War. We know at least they served in World War I for sure, and we haven't been able to verify this picture, but it was only in 1981 after Vietnam and when Reagan came in, they wanted to kind of tighten discipline, and the Sikhs were kind of a unintentional, consequence of that, and some were grandfathered in, but then no soldiers had served for 30 years before we sued to get them in. So this is another example of where they will be protected by being able to say, look, you have to treat our faith just like you might not understand our faith. Sikhs are often confused for, Muslims, for a lot of other things. And this is an opportunity for government officials to remember that their religion, American Sikhs, enjoy the same protections under our Constitution as everyone else. And finally, I think my time's about running out, but I'm representing a group of students at University of Iowa. This is, 8, it's kind of cute. It's 8 students who got together, and they're business students, this huge campus, and they really want to learn how to live as better witnesses of Christ in the workplace. They're like, how do we be better witnesses? How do we live ethically with all these things that are going on, Me Too and competition and the stress of the business world? How do we live more effectively as Christians? And so there's like 6 or 7, 8 of them meet together every week, and they talk about, they have a Bible study, they bring in speakers once a month, and they strengthen each other in their faith. And they had a student who was gay, who was a member of their group, and he asked if he could be a leader. And they met with him, and they went through their leadership requirements, and they asked him about his view of the Bible. He explained that he was struggling with his sexuality. And they said, you're welcome to be a leader if you accept our views of the Bible and you're willing to live by them. And he said, no, I want to live as an openly gay man, and I think you guys have the wrong view. And they said, you're welcome to stay in our group. We'd love to have, you've been a wonderful member. We'd love to have you continue to be part of our discussions, but you wouldn't be a good fit because you don't share our understanding of the Bible and repentance and those kinds of things. So he filed a complaint with the university, and they were told they would be kicked off campus. They couldn't meet on campus. They couldn't participate in any of the campus activities as a group. And so we first wrote a letter to the university. They called our clients in, and they said, well, we recognize that just like if there was an environmental group, we couldn't force them to hire, to elect a climate denier as their president. So we know, we know you have a right to have your own leaders, but it's really unfair for you to have these beliefs that students don't know about, and they join your group, and then they find out later they can't be leaders. And I was like, you don't make any other group do that. Students are adults. They can find out, These are 18-year-olds we're talking about, at least, in most cases. And they said, well, we agreed. Okay, we'll write our beliefs out. So our clients added 3 sentences about marriage, their views on marriage, their views on sexuality, and their views on gender identity. And they added some other general principles about what it means to be a Christian. And they resubmitted their constitution. They were told, as long as you do that, you explain your views, we'll let you stay on campus. They resubmitted that, and we got a letter back that said, your statement of faith is in violation of our human rights policy, and if you do not revise it and resubmit within 10 days, you will be deregistered as a student organization. So you literally have a government official writing to a faith group and saying, you must change your beliefs to participate in campus life. So we, of course, sued. We got a judge who was harangued our clients. Don't your clients know that, this is who gay people are? And we're not asking anybody else to change. We just want to live in accordance with our own faith beliefs and be able to speak about those beliefs. It was a pretty amazing experience to take depositions where you bring in the university officials and you interview them. And I don't know if any of you saw the Mila Kunis interview where she had donated money in Mike Pence's name to Planned Parenthood. And it kind of blew up her Twitter feed because she was thinking this was really funny. And she had a lot of people like talking to her about it on Twitter. And she did an article a few weeks ago where she talked to the reporter, and she's like, I didn't know there were people who actually didn't support Planned Parenthood. You know, she's like, I just thought it was like a few crazies out there. And it turns out there's actually a lot of people who, and she's like, of course they're bigoted, but, they have some good reasons, and they're pretty nice, So it's kind of like literally someone who just like has never been outside this bubble of their own views. And it was like this with these university officials. I said to one of them, can students express their views on campus? Yes. Can they express their religious views on campus? Yes. Even if they're very offensive? Yes. Can they form groups and express them with other students? Yes. Can they be a registered student group and express them? Yes. Can they write those views in their constitution? And all of a sudden you just see like these light bulbs go off in his head, like, and he's like, no. And you're like, okay, let's try this again. and you kind of, and eventually they're like, oh yeah, I guess they can do that. Okay, so and then you go through again. Let's go through their constitution. What's offensive in their constitution, line by line? You've got to get them to say they can express their views. So you say, what about this line on marriage? Is this a problem? No. What about this view on sexuality? Is this a problem? No. What about this on transgenderism, which isn't even an issue in the case, but all of a sudden, again, he's like, oh, this is going to mess up my case, And he's like, yeah, that's a problem. Like, okay, how come? It's a violation of our human rights policy. You're like, okay, let's talk about that. How? And you're kind of trying to go through over and over, and you're talking about, their human rights policy prohibits discrimination on the basis of creed. And they define that in their training as creed is any belief on the basis of any deeply held philosophical belief, whether it's religious or not. So I said, so that could be a political belief, right? And then you walk them through these same steps, like what about if the Bernie Trump support club, and there's a MAGA guy who wants to come in and again, you just see in their minds like, oh, I don't know how this all works together. So, and another official who just said, yeah, I knew this was, this raised red flags in my mind. Yeah, this sounds like religious discrimination. Yeah, why'd you do it? My lawyers told me to do it, So, these are not people who are acting with, like, animosity toward religion, but they're not treating religious views with the same respect that they would treat pro-Bernie Sanders views or other, the student who was not allowed to be a leader started his own club called Love Works. That's a Christian group that's affirming, a Christian group that's gay affirming. And he's allowed to be on campus and express his views, and that's great. Under our constitutional system, that's how it should be. People should go out and be able to have groups. But these university officials, another one I was like, so talking about, is it beneficial for students at a university to confront ideas that are different than theirs? He's like, there should really be some studies about that. So these are your tax-supported university officials. So I just share these examples to show that there is a wide range of, this is an important principle that unfortunately government officials still need to be reminded that they have an obligation to treat all religious beliefs and non-religious beliefs with equal dignity. And government officials cannot elevate one conscientious belief over another one. And that's an important principle that will protect all Americans for a long time. Thank you very much.
Hello, so my name is Eric Hall. I am so pleased to be here. I am a lawyer in private practice. I practice in Colorado Springs, which is where I grew up, with a private law firm. And our law firm has a religious institutions group, so we are doing religious liberty law all day long, and that is a great privilege. I was asked today to do the very technical part of this talk, and that part is describing to you all the Colorado Civil Rights Commission and its location within Colorado government, and the details of how it works and what Colorado law is in this respect, because it was the Colorado Civil Rights Division / Commission that heard the Jack Phillips case for the Masterpiece Cake Shop. So what you just heard Eric Baxter talk about is a very important part about being a lawyer, and then I'm going to describe a different part about being a lawyer, which is digging into the statute books to describe the details of a specific area of law. So if you all are interested in being a lawyer, this might either move you in favor of or against being a lawyer. But here we go. So the Colorado Civil Rights Division, and it's called both the division and the commission, is a part of the executive branch in Colorado. So like with the federal government, we have the judicial, legislative, and executive branches. So we're talking about the executive branch. There are 8 principal departments in the executive branch for Colorado. They are the Department of Regulatory Agencies, and that's where the Colorado Civil Rights Division lives. And in addition to DORA, the Department of Regulatory Agencies, there's also Law, Revenue, Treasury, Public Safety, Local Affairs, Natural Resources, and State Personnel. So you can think of kind of the governor at the top, and then these 8 different branches, one of which is DORA, and underneath that, Colorado Civil Rights Division, okay? What does the Department of Regulatory Agencies do? Well, they regulate, right? Hence the name. Well, what do they regulate? They regulate professions, so they regulate lawyers, they regulate doctors, accountants, physical therapists, all sorts of professions. So they regulate professions, give licenses. This is your state government. And what else do? They prevent discrimination, right? And that's what the Civil Rights Commission does. They do it in employment, they do it in housing, they do it in advertising, they do it with persons with disabilities, and they do it with public accommodations, right? And the public accommodations part is the part that affected Jack Phillips, okay? So trying to keep this all organized here, those are the areas of the Colorado Anti-Discrimination Act, otherwise known as CADA, that the Civil Rights Commission kind of oversees. Okay, as to employment, you might be familiar with the EEOC, the Equal Employment Opportunity Commission, right? That's the federal level. The CCRD, or CCRC, depending on where you are in the process, is the state equivalent, right? At the federal level and the state level, you can't go to court with an employment dispute unless you go through one of these agencies. Why? For a lot of good reasons, but one of them is to keep all these employment disputes out of the courts. Otherwise, they would overwhelm the courts. So you have to go through one of these regulatory agencies, either the EEOC at the federal level or the CCRD in Colorado. Okay, there is the division and the commission. First, the division. The division has a director, and the director is appointed by the executive director for DORA after good faith consideration by the commission. Okay, what's the duty of the division? To receive, investigate, and make determinations on charges of discrimination. So if you feel like you're discriminated against in Colorado, you can pull this up online. Those of you who have phones or computers sitting on your laps, you could actually pull this up, and you could quickly Google a charge of discrimination, to file a charge of discrimination with the Colorado Civil Rights Division. And you could fill that out. It's a 2-page form. It's very easy. You fill it out, and you file it, and then a charge of discrimination has been filed on your behalf with the division that they then investigate. So that's what the homosexual couple that came to Jack Phillips did, right? They came to him. They said, we'd like to buy a wedding cake from you. And he said, great, I sell wedding cakes. Oh, we're a same-sex couple, and we'd like to buy this wedding cake to celebrate our same-sex union. Now, at the time, Colorado didn't recognize same-sex marriage, so their plan was to get married in Massachusetts and then come back to Colorado where they lived and celebrate their same-sex marriage here. Jack Phillips said, I'm sorry, I don't, because of my religious beliefs, I will not sell you a same-sex wedding cake. And so what did they do? They filed this charge of discrimination, okay, against him. So then what happens next? Well, the division investigates. How do they investigate? They have what's called deputies. The deputies do the investigation. They can gather evidence. And at the end of that, they make what's called a probable cause determination. And that's a determination by, again, one of these bureaucrats to say, okay, is there probable cause that Jack Phillips, in this case, discriminated against this couple? And they found yes. Okay, so where does it go from there? Well, then you can, in the Jack Phillips case, the commission said, well, one of our powers is to appoint what's called an administrative law judge. So they appointed an ALJ who then made findings about what happened. That's very important in this case and in every case, because any lawyer will tell you What wins a case? The facts, right? Facts trump law. And if you have the facts, argue the facts. If you don't have the facts, argue the law. If you don't have the facts or the law, argue the rules of evidence to try and keep the facts out, to keep the bad facts out. That's how practicing lawyers practice law. So it's very, very important to figure out who is your fact finder, all right? And so Mullins and Craig went this route because they knew this is the sort of fact finder they wanted to have. So the ALJ then made certain factual findings, and then where did it go from there? It goes up to the commission, and the commission is a politically appointed body. So Colorado Civil Rights Commission, right, is part of the division, kind of paired together. They have 7 members. And the 7 members are appointed by the governor, and now, I think thanks to the Centennial Institute, in Colorado, they must be approved by the Senate. Before, I think they were just appointed by the governor. But you have to get your minds around the fact this is a political body, and there are certain rules about who can serve on this body. The rules are, first, they're supposed to be 7. They serve 4-member terms. 2 are supposed to be from the business community, 1 small business, 1 large business, 2 from state and local government, 3 from the community at large. The law says, the statute says, there's supposed to be diversity on the commission. At least 4 members must be from groups who might be discriminated against because of disability, race, creed, color, sex, sexual orientation, national origin, ancestry, marital status, religion, or age. So 4 of the members are supposed to be from groups that come from there, so identity politics, right, written into the statute. No more than 6 of the commissioners must be affiliated with a major political party. No more than 3 with the same political party, right? Democrats, Republicans. Right? If you have a Democratic governor like we do now, he can't pack it with just Democrats. You can't have more than 3 from any political party. And then for the geographical diversity angle, it's supposed to be as may be practicable. So sort of kind of try for geographical diversity. The current commissioners, I found this interesting as a practicing lawyer, the current commissioners, there are only 6 of them. I don't know why there's not 7 commissioners, because they're supposed to be 7, but there are 3 Democrats, 2 unaffiliated, and 1 Republican on the current commission. The 3 of the 6 commissioners, their terms expire March 16th, 2019. At the end of this, in my little segment, I'm going to make a couple broader conclusions. One of them is elections matter, right? Because who our governor is and who our state senate is means who's on this commission, right? And who's going to appoint the three of these commissioners whose terms end March 16th, 2019. All right, what can the commission do? The commission can make regulations. I'm not going to go through all their powers, but make regulations. That's one of the things the commission can do. That is very important. Why? Take, for instance, sexual orientation. Sexual orientation was added as a protected class in Colorado, not federal law, but in Colorado in 2008, right when we had a Democrat-leaning governor and legislature. The CCRC commission, they make regulations about sexual orientation and what that means. And if you want to find out what's legal in Colorado as to transgender, you look at the regulations, which again are made by the commission. I won't go into that now, but when you read them, you can see, oh, these regulations about transgender rights were written by a more liberal-leaning group of commissioners. Keep going. What else can the CCRC do? They can hold hearings, which is what they did with Jack Phillips, and the hearings that were held, as Eric Baxter talked about, some of the statements by the commissioners themselves were anti-religious in flavor, which is why Kennedy and the majority in the Supreme Court case overturned it, because they said the government itself, i.e. the commission, can't be against religion when they're supposed to be considering, when they're supposed to be respecting religious rights of all the people that come in front of them. But they make regulations, very important, hold hearings, very important, appoint ALJs, so it's the commission that appoints the ALJ, right? So again, when your fact finder is so important, if you're in front of the commission, they appoint the ALJ, they're going to appoint somebody that they like to be the fact finder. Okay, very important. What else can they do? Skip all that. Okay, the hearing process I've already described to you. Okay, what remedies can the commission order under the statute? Important. First, they can give an order requiring the respondent, Jack Phillips in this case, to cease and desist from whatever discriminatory action he is taking. Second, they can order someone to take such action as it may order in accordance with CADA, the Anti-Discrimination Act. Now, as you listen to that, you go, wow, that's very broad. And I say as a lawyer, you're right. That is extremely broad. They have massive latitude to make any sort of order. So what sort of order did they give to Jack Phillips? As Eric Baxter mentioned, they required training. They required staff training. Now, I've never dug into to figure out exactly what that staff training was exactly, but it does chill me as an American and as a lawyer to think this commission group ordered some sort of staff training to Jack Phillips and the other people that worked with him to teach them what? To teach them that their religious beliefs were wrong? Well, that would be horrifyingly scary. To say, oh, you must comply with the law and here's what the law is? They probably already knew that after several years of litigation. I don't know, but that piece of it really concerned me and continues to concern me. But that they have that latitude for what sort of remedies they can give. What else? Okay, so what happens if you don't like the decision that the commission gives, like in Jack Phillips' case? You can appeal. Where do you appeal to? You appeal to the Colorado Court of Appeals, which is, of course, what Jack Phillips did. He lost at the commission level. He appealed to the Court of Appeals. But what's important as a lawyer is you don't go to a trial court where you can have a new fact finder, i.e. a judge, who's supposed to be independent of all these things. You go directly to the Court of Appeals. So it was the Court of Appeals that heard his appeal, and then the Court of Appeals supported the commission's decision, and then Jack Phillips appealed again on religious liberty grounds. Interestingly, right, his appeal went to the Colorado Supreme Court. They didn't take the case. I found, as a lawyer, I find that fascinating, that the Colorado Supreme Court didn't take this case, says, no, this case isn't important enough. And so they appealed to the US Supreme Court, which is unheard of, and the US Supreme Court took the case, straight from the Court of Appeals. Very, very unusual. What else? Oh, yeah, so one important rule here is at the Court of Appeals level, findings of fact shall be conclusive as long as it's supported by substantial evidence. So again, the importance of the evidence that is given at the ALJ stage or the commission stage, that's the evidence that must be followed at the Court of Appeals. You can't introduce new evidence, in other words. Okay, now moving on to public accommodations specifically. So we're getting more specific still from what the commission does generally to the Public Accommodations Law, which is what, again, Jack Phillips was fighting. Public accommodations in Colorado is defined very broadly. One part of the Anti-Discrimination Act just incorporates the federal law, which is very broad, and another part defines itself, which is very broad. Interestingly, the public accommodations definition specifically includes educational institutions, period. Educational institutions with no definition of public or private, with no definition of religious or non-religious. So query the CCU lawyers whether CCU is a public accommodation under that definition. Also, public accommodations statute says that sexual orientation is a protected class. Now again, keep in mind that the protected classes are the ones that are protected under law, right? Because, for instance, when dress designers didn't want to make the First Lady's dress, right? Could she have brought a discrimination claim if she thought, under the public accommodations laws of, say, Virginia, it was because she was a woman that they wouldn't make her a dress, or maybe because of her creed, like her political creed, that they wouldn't make her a dress, then maybe she'd have a case of discrimination there. But if it was just, no, we don't want to make you a dress, or like in restaurants, no shirt, no shoes, no service, right? That's not a protected class. You have to have a lawsuit, you have to be in one of these protected classes. Okay, so for employment, what are the 10 protected classes? Let me go over them because it's good contrast with public accommodations. 10 protected classes for employment: disability, race, creed, color, sex, sexual orientation, religion, age, national origin, or ancestry. All right, you can keep all those in your head. But one little note as to the employment part of the Anti-Discrimination Act. In the statute, there are two carve-outs for religious organizations. One is you're not even considered an employer at all if you are a religious organization or association unless you are supported in whole or in part by public money raised from taxation or public borrowing. So if you're a religious organization, you can discriminate on the basis of employment unless you take public money. Then there's a second carve-out for religious organizations. The employment part shall not apply to a religious corporation, association, educational institution, or society with respect to the employment of individuals of a particular religion to perform work connected with that religion. So, easy example, an evangelical university can hire evangelicals, right? That's the obvious one. Okay, I'm being told to wrap it up, so let me wrap it up. Public accommodations. Okay, so focusing in on public accommodations, two things to say. First, the Public Accommodations Law also prohibits publishing anything saying that we will not respect these protected classes. So, for instance, you can't publish statements like, we will not hire blacks, right? Think of the Jim Crow South. And let me say also, there are 9 protected classes with public accommodations. Let me just mention that religion is not one of them. And age is not one of them. So under the Colorado Public Accommodations Law, religion is not a protected classification. So someone under public accommodations could discriminate because of religion for public accommodations law purposes in Colorado, and it wouldn't matter. Okay. Oh, the last piece I will say is for public accommodations, you can either go to the commissions, kind of the commission route as I've described, or you can go to court. So you can actually go to court if you want to, but if you're Mullins and Craig, you don't want to go that route. You don't want to be in front of a judge and get a jury. You want to go the other route. One thing that I thought of as a lawyer is, if you want to change the law, Centennial Institute, is have a right of removal that if someone files with the commission, you can actually remove the case to court, so that you as the defendant don't have to be have to follow where the plaintiff wants to go. Okay, I will stop and just give my 3 concluding comments, which is 1, elections matter. Who people elect matters. 2, culture matters. Dean John Garvey, who I think is was dean at the Catholic Law School, said, if people don't care about religion in America, they're not going to care about religious liberty in America. And the third thing I will say is, by and large, I think the law states, generally speaking, that commerce is governed by the state where you're doing commerce. So if Jack Phillips wants to sell cakes generally, or other products, he's going to be governed by the laws of Colorado by and large. Justice Kennedy says that in his majority opinion. Justice Gorsuch says that in his concurring opinion. And Justices Kagan and Breyer say that in their concurring opinion in the Masterpiece Cake Shop. So this idea that Jack Phillips or other vendors, by and large, we'll put aside expressive conduct for now, which we can talk about later, but by and large, you're going to have to follow the laws of the state. All right. Sorry, hope that wasn't too boring.
We are now going to introduce to you Brenna Gross, nee Brenna Moore. She's one of our best students. And she was a 1776 scholar here at Centennial Institute. She's a third-year law student on the Nebraska Law Review. And she's going to give us a law school perspective, if you will, and what is being taught, and particularly with her work in connection with the Blackstone case. So, Brenna, are you there?
Can you see me?
We can.
Yes?
Yes.
Awesome. Well, thank you. I'm going to go ahead and get started if that's okay, if you can hear me all right. Perfect. So I wanted to thank Centennial Institute and Colorado Christian University for live streaming me in. This is awesome. And I wanted to thank them for the platform that they have given me as a launching pad to being where I'm at right now. A lot of professors at CCU inspired me to go to law school, including Dr. Shoemaker, including Dr. Ussery, so I want to thank them for that. I have a picture here of me and Jack from a couple of weeks ago. and I drove through Colorado on a family vacation, and I was working at Centennial Institute a few years ago when he made a cake for John Andrews, and Jack always jokes that he jokes to my husband that he has a photo of my husband's wife on his computer because he has a picture of that cake and me holding the cake in his computer. So I always think that's funny. So Jack is a good friend. He'll be back in Nebraska for a banquet with my husband's organization in October. And he has also come out to Nebraska to testify in the Nebraska legislature, trying to stop a bill that is written exactly like the Public Accommodations Law that was used as a sword against him in Nebraska. So we're really thankful for him. And one last thing, I am teaching the Constitution to middle schoolers this Friday for Constitution Day. So I think it's fitting that I'm doing this event and then also working with middle schoolers this upcoming Friday as well. So can you still hear me okay? Perfect. Awesome. So I kind of want to talk about some of my personal experiences, how I got to where I am right now, and then I thought it would be good to kind of walk through the federal jurisprudence, so what's happened in the courts for religious liberty on the federal level, and then going into how Congress has responded with that, what it looks like in the states right now, and then kind of arguing why it is so important, like what Dr. Shoemaker was talking about, to be focusing on a lot of these issues at the local level as well. So I'll start with my experience with ADF. I was a Blackstone Fellow in 2017, class of 2017, and it was really a life-changing experience. ADF is on the front lines of all of these religious liberty battles, free speech battles. They've won their last 9 cases at the U.S. Supreme Court in the past decade. They're really successful. They really believe that all people should be treated with dignity and respect, and that all faiths should be protected with the religious liberty that we have in America, and that's really their goal. So that has been a great experience. I've had, again, incredible mentors at CCU who have sharpened the way that I think about religious liberty and attack these issues, really inspired me to go to law school to fight on the front lines of the religious liberty battle. And I've also been really blessed with a great law school professor. His name is Rick Duncan. He does do a lot with the Federalist Society nationwide. And I took Constitutional Law 1, which is just the general constitutional law course, a First Amendment constitutional law class from him. I took Constitutional Law Seminar, so I wrote a paper on the NIFLA case, which was the California case where they were compelling speech of pro-life pregnancy centers. And I got to research and write a paper on that. So I've had a really good experience and have had a lot of experience and tried to focus really on the First Amendment issues throughout law school. So I want to start with really why our Constitution is so important. And Dr. Usry touched on this, and he was saying that it was it is the oldest surviving Constitution, and there are reasons for that. And I think, number one of the things that makes our Constitution unique is that it's a written Constitution. And that sounds crazy, it sounds weird, but in reality, a lot of constitutions aren't even written down in a document. So that is something that makes our Constitution unique. Number 2, it recognizes natural rights. It sees all human beings as holding inalienable rights that are granted by God. We all know this. We've been taught this, but we sometimes don't realize how unique that is for a country. And number 3, our Constitution's framers structured our government to secure those natural rights. And this was radical. This is what makes the American Constitution experiment so unique, is that we have framers who say you hold rights, and we are going to, in this document, grant the government some power to exercise over these rights, but your rights don't derive from the government. So you look at religious liberty and religious freedom. That is something that the founders believe is inherent, that we should all be able to exercise. And the government has a very limited amount of power over that right. It should, and we're seeing that change over the past couple of decades. Neil Gorsuch was labeled as a natural law originalist in an article recently written by the Witherspoon Institute with Ryan T. Anderson. And that's what they called him because he recognizes that's really what the founders understood. All Americans, all people to be holding these natural rights, and government secures those. So it's really what makes the American Constitution and what makes America, the great American experiment, so unique. And I think it's important to recognize those. So I want to go into what the jurisprudence has looked like over the past 60, 70 years for the First Amendment, specifically religious freedom, and then how that has translated over into the states and what the states should be doing about it. So you have in around, I think it was 1940, that the First Amendment was incorporated against the states. So before 1940, the First Amendment only applied to the federal government because it says Congress shall make no law. It doesn't say the states shall make no law. It was binding to Congress. So it wasn't until 1940 that the First Amendment even applied to the states. And then starting in the 1960s, the U.S. Supreme Court started developing jurisprudence that was really in favor of religious freedom. So they said that if your free exercise rights are unduly burdened in any way, then the government has the strongest level of scrutiny put against them in order for them to prove that, in order for them to show that it's okay for them to burden your rights. So it was very hard for the government to win if they were burdening your religious freedom rights. And then you have in the 1990s what's called the Smith case. And this case is what says if a law is neutral and generally applicable, then regardless of the undue burden that it places on your religious exercise, you don't have a claim. So it's a very low level of scrutiny that the U.S. Supreme Court has to apply to these laws if it's neutral and generally applicable. So what happened is Congress came in and enacted what's called RFRA, the Religious Freedom Restoration Act. And what that did was reestablish what happened in the 60s, saying if your religion is unduly burdened, then the government has to meet strict scrutiny. And what ended up happening with RFRA is it was invalidated against the states. So it applied at the federal level, but didn't apply at the state level. So once RFRA was invalidated against the states, then Smith, the neutral and generally applicable rule, which you see that language in the Masterpiece case, that then applied to the states. That was the floor that all of the states had for the First Amendment. So you had a few responses from states. Some states passed their own RFRAs. I know Colorado has tried to pass a RFRA, and it was not successful. I'm not sure how many years ago that was. Some states have said our state constitutions provide more protection than the federal First Amendment free exercise clause. And that's okay because the federal constitution is a floor, not a ceiling. So you can grant more rights as a state, but you can't take away rights from what is in the federal constitution, if that makes sense. So some states said our constitution is actually stronger than what the Smith rule says. And some states, including Nebraska, and I'll talk about this, have said, you know what, our religious liberty clause in our state constitution just means exactly what the Smith case said. So we're just going to apply that really low level of scrutiny to religious freedom cases. So one of the things that I have focused on in law school is this issue on the state level, where our Supreme Court decided to say, we aren't going to look at the original meaning or the original intent of our state constitution's religious freedom clause. We're just going to apply whatever the federal government says, whatever the U.S. Supreme Court says about the federal constitution. And so I am publishing a law review article about that, saying that's really not what states are supposed to do. We have this history that we can look at for what the meaning of it's a conscience clause, what our conscience clause says in our state constitution. And that's really what the court should be looking at when it's looking at religious liberty religious exercise claims in Nebraska. So I'm really hoping to show we really should have stronger religious liberty protections in Nebraska than even what the U.S. Supreme Court has said the Free Exercise Clause requires. So the reason that I'm so focused on this and that I have written on this in law school is because I really do think that we should be focusing more on the state level than we tend to do. And I think watching all of these really big battles at the U.S. Supreme Court is really exciting, and it can get us really hyped up. But at the same time, a lot of the battle is happening in the states and in the state legislature. So like I talked about, Jack came to Nebraska to testify to stop a bill that had the same language as the Public Accommodations Law that was used as a sword against him. And that's happening in Nebraska, which is a very conservative state, and that could have harmed a lot of people in Nebraska. So being able to have people on the front lines in states making sure that really good law is getting passed and really bad law is being stopped, I think that is really where we should see morality flourish, is in our small local governments and our communities, and that's one way to do that. So other than that, that's really mostly what I wanted to talk about. I think that religious liberty is something that once it's gone, everything else starts falling away, and it's really hard to get back from there. So I really appreciate Centennial Institute and CCU having this panel. For Eric Baxter and Eric Hall, Dr. Shoemaker, Dr. Usry, for all of you being on the panel. And thank you for inviting me to give my little blurb about this issue. I'm very passionate about it, and I really appreciate your time.
Well, thank you, Brenna. I'm really pleased to be here tonight. I was awakened at 3 a.m. due to a sewage problem, a broken pipe at my mom's place in Boulder, and I spent all day there, so this is much better than that. And because of that, whatever I say tonight, I'm not responsible for, because I'm just brain dead. You know, we lawyers like this wonkishness when we're involved in studying and spouting off about legal issues. You know, strict scrutiny tests, compelling government interest, narrowly tailored for least restrictive means. Wow, that's fun to parse through. Neutral and general applicable laws. Well, that's exciting from a mental gymnastics standpoint. Sincerely held religious beliefs of a fervent adherent. Yes. RFRA? Oh boy, that is fun. But sometimes we can get lost in the forest for the trees when we're using these analytical tools. So what is this all about? One of my mentors in law school at CU Law School told me, good lawyers clarify and simplify. I'm not that good of a lawyer. These guys are much better lawyers than I am. Brent is a much better lawyer than I will ever be. But frankly, I want to try and clarify and simplify this for us tonight. Get down to brass tacks and what this is all about. Folks, this is about woulda, coulda, shoulda. Jack Phillips and baking a same-sex wedding cake. He would, but he won't. He could, but he can't. He shall, but he shouldn't. Woulda, coulda, shoulda, in part. Should he bake that cake and deny his freedom of conscience? That's what it comes down to. This case and what we're talking tonight about is all about freedom of conscience, or what we in the evangelical circles will call soul freedom. Period, the end. Freedom of conscience is the right to think and believe as one sees fit. Freedom of conscience is what the First Amendment is all about. We're free to think and believe as we are led to do so by our God, or as we want. No government, local, state, or federal, can tell me what to think or believe on freedom of conscience or soul freedom. Religious liberty is a civil rights issue, by the way. Its moral basis is the recognition of freedom of conscience, which is fundamental to human dignity. A black pastor, Corey Mitchell, in Creedmoor, North Carolina, said that, and I can't believe it. No, I believe it fully, that it is a civil rights issue. You know, folks, it's high time that we all understand my freedom doesn't extend so far that it would deny you yours freedom. My freedom does not extend so far that it would deny you yours. Sometimes in this world, you have to restrain your own freedom in order to recognize the liberty of someone else. The Free Exercise Clause was designed to keep government from unnecessarily interfering with religious practices. I'm an international lawyer and internationalist. I want to tell you about a case in Canada that is very troubling. And it's related to what we're facing down here. And it may prescient what's going to happen. So a couple months ago, Trinity Western versus Legal Society, a decision was made by the Canadian Supreme Court, a 7-2 decision that said the civil rights of the LGBT community overcomes the sincerely held religious beliefs of Trinity Western University, a Christian university, saying it's proportionate and reasonable, whatever that means, proportionate and reasonable to limit religious rights in order to ensure open access for LGBTQ students. And thus, TWU can't have a law school with a Christian worldview. They do have a lifestyle covenant that the Law Society accreditors didn't like. Doesn't even mention LGBTQ in any way, but the court found the public interest of the law profession and the accreditors gives them the right to promote equality by ensuring equal access, supporting diversity within the bar, and preventing harm to LGBTQ students. It's important to note that 8 of those 9 judges of the Canadian Supreme Court said that Trinity Western's religious freedom was indeed violated. But the majority held it didn't stand up against the principles of legal equality and non-discrimination, hinging basically on the progressive gender definition of marriage between same-sex people. In other words, accommodating religious diversity is in the public interest, but just not enough to get past the accreditors. Here's what's most interesting to note from my standpoint is the Canadian Educational Accrediting Commission said to Trinity Western, look, Trinity Western, if you change or do away with that part of your lifestyle covenant that deals with heterosexual marriage between a man and a woman, they will let you have the law school. That was a settlement offer. And what did TWU say? No way. That's part of our core tenets of belief. We're not going to change that. So they suffer the consequences. This case is about government-prescribed beliefs about gender and marriage and accreditors trying to force Trinity Western University as a Christian institution to believe something that's in contravention of their theological core. And they said, no, we're not going to do that. Now, we're worried about that here in the United States. It's easy for us to say, well, it's Canada, that won't happen here. Nah. We're very alarmed over our faith-based mission and potentially our lifestyle covenant of the overreach of accreditors when it comes to our mission. Dr. Sweeting testified about that last week, saying we need to better define what it means to respect religious mission by the Department of Ed and our accreditors. Let's flash forward to the Masterpiece Cake Shop case and how that ties in. You know, one of the things that's misunderstood by the courts of many people is for Christian evangelicals, our faith expressions are not limited to worship on Sundays. They're part and parcel of a non-compartmentalized life every day of the week, even or especially at work. As Jack said in an article, editorial in the Denver Post, quote, my life, my entire life belongs to Jesus, and I believe that everything I do should honor him. As the Bible says, whatever you do in word or deed, do everything in the name of the Lord Jesus. Jack owns a business. He's not just an employee of Masterpiece Cake Shop. He owns it. He's a practicing Christian whose faith is on display every day and every minute of his work. That begs the question, isn't the government wrong to punish Jack for living out his faith? Now here's where my wife has said, don't overreact, Kyle. But I do what I do best, so I'm going to overreact because somebody needs to. As Eric Hall was talking about, the Colorado Civil Rights Commission has some extraordinary equitable powers, scary equitable powers. And you know, this was noted in the Masterpiece Cakes decision by Kennedy twice. He talked about it twice in there. He said, here's what the statute says, here's what they did. They ordered Jack to cease and desist from discriminating against same-sex couples by refusing to sell them wedding cakes. It also ordered additional remedial measures, including comprehensive staff training changes to any and all company policies to comply with this order, prepare quarterly compliance reports for a period of 2 years, documenting the number of patrons denied service, along with a statement describing the remedial actions taken. Are you kidding me? This is the Colorado Civil Rights Commission was literally taken out back to the woodshed by the United States Supreme Court and said, this kind of animus can't exist. This is unconstitutional animus. And so now they want to turn around and say, yeah, let us train you, Jack. Let's spend time figuring out how to get your mind right, how to change your theology, how to be reformed. Soul conscience, soul freedom, freedom of conscience. You know, this could go from remediation to reform to re-engineering to rejection and recanting if you don't watch out. Just get your mind right, Jack. We're just trying to remake somebody and how they think and believe. If that's what it is, we're all close to trouble, perilously. You know, my wife and I have had the privilege of living in many places in the world, friends all over the world. And so when they find out about this case, and they know I'm a lawyer, they go, wait a minute, we don't understand this at all. The United States, the bastion of freedom, and what does this come to? Your government is trying to reshape the mind and belief system of somebody, alter that, who you are, into some image that the government has. You know, my wife and I have lived in communist countries. We've experienced totalitarianism in various places in the world. We know people that have gone through the Cultural Revolution in China. They're friends. They've been through re-education camps. They've had to engage in self-criticism programs in order to change their minds and their behaviors about how they think. We need to be really careful of this. This is a challenge to all of us. And we need to stand up. Some of us need to go screaming in the night, stop, stop, stop. Doesn't matter if you're in favor of the LGBTQ community in this case or against it, because this kind of coercive, psychological coercive power of the Colorado Civil Rights Commission is frightening. We're on a precipice here. We need to be careful. If we go down that slope, we may never get back up. Now, I could spend a lot of time talking about dignity, stigma, equal access accommodations, the 14th Amendment, but I want to get just right to the tail end so we can take some questions. You know, the great playwright Eugene O'Neill said, man is born broken, he lives by mending, the grace of God is the glue. The grace of God is the glue. Folks, we need to pray for more glue. We need to pray for more grace. We as Christians need to be out front demonstrating grace, because God has been and is gracious in ways that we can't even count, not to mention our salvation. You know, for a while I thought, and I was joined by a good friend of mine here on the faculty from Wyoming. I was born in Wyoming. We Wyomingites have to stick together. He's a professor and a pastor, and we both just said, why doesn't Jack just bake the cake? Just bake the cake, Jack. Wouldn't that be gracious? Well, you know, the more I see this, the more I realize, don't bake that cake, Jack. You're subjected to the bullying, mental torture, the loss of income, the humiliation, the stigma put on you by a government for your sincerely held religious beliefs and trying to get you to change those. You know, Martin Luther at the Inquisition, the Diet of Worms in 1521 said to the controlling power of the day, this is where I stand. I can do no more. So help me God. Pastor Martin Niemöller said, first they came for the disabled. Since I was not disabled, I said nothing. Then they came for the homosexuals, and I was not homosexual, so I said nothing. Then they came for the Jews and the blacks, and I was not a Jew or a black, so I said nothing. Then they came for the gypsies and the Jehovah's Witnesses, but I said nothing. And here's where I add, then they came for the evangelical Christians, and I said nothing. And then they came for me, and there was no one left to say anything. Now, I'm going to bet you're never going to hear this in the context of a constitutional law debate. on religious freedom, but Tom Petty and the Heartbreakers wrote a song, I Won't Back Down. Johnny Cash sang it too, I won't back down. It says, I'll stand my ground, won't be turned around. I'll keep this world from dragging me down, gonna stand my ground, and I won't back down. Well, I know what's right, I got just one life in a world that keeps on pushing me around, but I stand my ground and I won't back down. Don't back down, Jack. Don't recant, Jack. Don't bake that cake, Jack, no matter how rough the Colorado Civil Rights Commission makes it on you. Don't bake that cake, Jack, until somebody, the U.S. Supreme Court or the Colorado Supreme Court or the Colorado Civil Rights Commission or some legislature recognizes your religious liberty, civil rights as fundamental to your dignity and our dignity as well. Once they do that, then bake the darn cake, Jack.
Suppression of religious rights in America began in 1948 with the separation of church and state, which I think is unconstitutional and can be proved unconstitutional. If I had $25 million, I would do it. What do you think?
What do you guys have?
Well, you may be referring to the Everson case. I guess I'll take the first stab here. Where the court talked about first kind of introduced that phrase into our modern legal parlance, and said a lot of things about you can't prioritize. The government cannot do anything that would favor religion over irreligion or one religion over another. There's some truth in that. We don't favor one religion over another under the First Amendment. But the First Amendment itself favors religion over non-religion, right? I mean, that's the whole purpose of the First Amendment, is to say that religion is something that as an American people we agreed had a special place, and that we were going to respect people's response to a higher authority, their belief that they had something that was above the state that they had to respond to. So as long as we can, unless the government has a compelling government interest, we would protect that right. And so I think it is important that separation between church and state has become a widely misunderstood principle, and really shouldn't. I just argued a case in the Third Circuit Court of Appeals in Philadelphia on Friday about a county seal. Lehigh County has a seal that they've had for 70 years. It has 13 images on it of things that reflect the history and culture of the county. And there's a bison head back when there were bison in Philly or in Lehigh County, which is further north than Philly. But cement factories, draperies, books, a heart signifying patriotism, and a cross, because Lehigh County was settled by refugees who came to America seeking religious liberty. And they were sued by the Freedom from Religion Foundation, saying you can't do that. That's endorsing Christianity. It's not very effective. It's like only 60% Christian in Lehigh County. But our argument was, look, the Constitution doesn't require us to forget that there were religious people who came to America. The religious communities had an important role and continue to play an important role in American life. And so that separation of church and state doesn't accurately reflect the fact that it's okay to make acknowledgments that religion is a part of our history and culture, and it has a legitimate place, even when the government recognizes it.
There's some other questions. We're running out of time, so I'll make sure that they answer.
Hi, thank you. Many people on the left have the view that in support of religious freedom against LGBTQ issues is no different than 75 years ago support of anti-biracial marriage or Jim Crow laws. Do you have a concise way to explain how they're fundamentally different?
Yeah, that question was central to the Masterpiece Cake Shop case. No, is the short answer. I don't have a concise way to say that they're different. I mean, there are longer ways to say that they're different. To say that the Jim Crow society of the South is different from America in 2018, and whether the homosexual group is a discriminated against minority, or whether they're actually one of many parts of our society. I think that's one way to distinguish the two. I think it's historically accurate that blacks in the South were subjugated, and I think it is also historically accurate today that gays generally are one part of our society in America that some people like, some people don't. But I think that's one difference, and the law is a reflection of our time, always, and but the fundamental question, I think, in our democratic republic is who makes the law, and fundamentally I think we want to say the legislature makes the law with the executive, governor, or president signing the law, which comes back to, again, elections matter.
So the latest Civil Rights Commission hate crime against Jack Phillips involves an attorney here in town who was a man and became a woman and wanted a cake to celebrate the 5-year anniversary of this occasion. And just wondering what you think would happen given the state law protection of gender identity. If someone were to go into a cake shop, kind of like this fella Jack did, wanting a Bible cake, but to celebrate transition therapy, because we have society right now really almost encouraging people, including children, to become transgender. At the same time, we have Colorado legislators and California legislators trying to outlaw and otherwise forbid transition therapy, where one transitions from a homosexual lifestyle to a heterosexual lifestyle. Would that be protected if the person went in and wanted a cake to celebrate transition therapy?
Who knows, really? I mean, we're trying to speculate what the Colorado Civil Rights Commission would do. What we do know is this, and this is in the category of what don't you understand about no. That 3 weeks after the Masterpiece Cake decision came down from the U.S. Supreme Court, the Colorado Civil Rights Commission found probable cause that Jack had violated transgender rights. You know, I just find that amazing. What don't they understand about no? Go ahead.
I think the answer is easy. If the Civil Rights Commission or a court in Colorado heard that case, I think they would say, yeah, a baker, any baker, Jack Phillips or any other, refusing to make that cake is just like the 3 bakers that refused to make the William Jack cakes, because those are specialized cakes that nobody makes. The hard thing about the Jack Phillips case with Masterpiece was people were arguing over what sort of cake is this, right? So Kagan and Breyer were saying it's a wedding cake. But Gorsuch was saying, I think Gorsuch is right, no, it's a same-sex marriage wedding cake, right? And Phillips knew it. And so it was that, as soon as he knew it, he said, that's why I can't sell it to you. But this, like a celebration of transgender cake, no, nobody's going to make that cake, and nobody should. Nobody has to.
We have to get where we live. We recognize that we must live in a society where not every little affront, not every little slight becomes a constitutional case. We have to recognize that we can't go around playing gotcha in businesses to try and say, see, I gotcha, I want to sue you because you didn't do what I thought you should do. I think we have to figure out that no society ever succeeded by suing itself to death, and that social dignity rights are not protected by the U.S. Constitution. If we don't get that right, we're going to spend the rest of our lives trying to clean up the carnage of our adversarial system of law.
One last question. What do you think the significance was of the Colorado Supreme Court not taking Jack Phillips's case, or was there none at all? What does that say to you?
To me, you never know why any Supreme Court, Colorado or U.S., doesn't take a case. I remain puzzled as to why they didn't take that case. So I don't have, but it's hard to read into it, and because you're just guessing.
All right, last question to a student. Is there any student here at CCU that wants to ask the last question? Go ahead, right here. Hold on real quick till I give you the microphone so they can hear on the way. Great.
My question is kind of just clarifying for my own knowledge of the Jack Phillips case. There's a lot of confusion for me in what I've researched and what I've been told as to, I guess, the reason for the cake, whether he knew into going, like he said yes at first, and then once they sat down to plan, and then also with the verdict, I guess is the word, from the Supreme Court, whether it was the Colorado Civil Rights Union, sorry, I don't know the word, whether it was just because they didn't handle it properly, or if it was, again, in defiance of freedom of association or expression or religious freedoms. Yes.
So yeah, I'll answer that. As to the facts, you know, what Jack did exactly, the Supreme Court didn't get into it. It just said, you know, we're not going, and so this new round, there could be a decision from the Supreme Court where they say, yeah, the Colorado civil rights law trumps, and Jack can't deny this gentleman the cake. I think that's unlikely in this case. There was a lot of dispute in the last round about whether a cake is expressive, but where someone comes to you and says specifically, please make this to celebrate my transgender, you know, they're clearly asking for you to do something expressive, which I think the court would say is protected. As far as the court's decision, I think the court was a little bit vague. It just said whatever they did in the past to Jack Phillips has to be undone. They didn't say whether they could like they didn't say whether they could go back and redo it. I doubt they would do that, but just that initial action was undone, but it doesn't mean anything really about what could happen going forward, except that the commission has to respect his religious views and give them equal dignity.
You know, the case was about animus, unconstitutional animus, demonstrated by the Colorado Civil Rights Commission against Jack. And the court says, in essence, this Colorado cannot do. This animus will not stand. And so I think that's important for us to understand, that when the Colorado Civil Rights Commission begins to take on other cases involving evangelical Christians, how are we going to know that that animus is gone? Really? The other thing I want to point out is Kennedy, in the masterpiece decision, quotes himself in another case. I love this. And he's quoting this line. This is really important, I think. Legislators may not devise mechanisms, overt or disguised, designed to persecute or oppress a religion or its practices. Sometimes in these cases, I know when Scalia was here, he said, look, when there's a punt decision, you have to look carefully at the concurrences, what is said and what's not said. And I think that what we're going to be looking at clearly in the future is whether state governments can design mechanisms to persecute or oppress a religion in order to uphold LGBTQ rights versus freedom of exercise and freedom of conscience. That's a tough one, but I think that's where we're headed, and we are going to have to be very smart about how we handle that.
Great. I think all these gentlemen have had a great chance to put in a final word here, but Brenna, can you hear me? Do you have a final word you'd like to say?
I echo what Dr. Usry was talking about with Kennedy. I kind of want to mention that he went out with a bang when he was talking about religious liberty in the Masterpiece case, and there's some really good language there that I think can be used to apply to the Smith neutral and generally applicable rule to really help religious liberty from the federal level. I think there's some really good language in there that we haven't seen in over 20 years from the U.S. Supreme Court. So I would add that. I would also make one comment about kind of the relationship between like Jim Crow and what's happening with Masterpiece. And I think a really good way to look at it, and this is just a simple analogy, it doesn't answer the whole question, is if you think about African Americans during that time, they weren't even able to find a restaurant to sit down at. They weren't able to stay at a hotel because people wouldn't let them in. You look at the situation of Jack's case, and he was going to bake them anything. He was going to sell them anything in their store, but he could not create a custom same-sex wedding cake. But he could refer them to someone down the street. There's probably 50 bakers in a 20 mile radius in Denver, Colorado, who would have baked the cake for them. So the amount of oppression and discrimination is very different in Jack's case than from the Jim Crow era. So I did want to point that out too.
All right, as we close here, just one reminder. During the last Supreme Court nomination with Brett Kavanaugh this past week, Brett Kavanaugh used the word precedent when it came to the Masterpiece Cake decision, which is a clear indication that he respects the importance of religious freedom. He spoke about it with Hobby Lobby too. So I think it's clear that we have a Supreme Court nominee that understands all these issues at stake and that will rule in favor of the importance of religious freedom, which is great to recognize. Let's give all of our panelists a final round of applause. Our next Issue Monday will be right back here October 8th as we explore drug overdose and the challenges we face here in Colorado on that. So we'll be right back here on October 8th. Thank you all. God bless you.